This is a Legal Resources for the Elderly Program presentation. This presentation is based on New Mexico law, but it is intended for informational purposes only. Because every individual situation is unique and there might be exceptions to the material presented here, we always recommend you seek the advice of a qualified attorney for your individual questions or concerns, and the attorneys at LREP would be happy to help you. This presentation is on landlord tenant law. My name is Scott. I'm one of the attorneys at LREP. LREP is a joint project between the New Mexico Aging and Long-Term Services Department and the State Bar of New Mexico. Our contact information is at the bottom of this slide, as well as at the last slide of this presentation. LREP is a free statewide legal helpline for New Mexico residents age 55 and older, and there are no income restrictions. So if you have any civil legal issue, please give us a call and we'll be happy to help you, whether it's about powers of attorney, estate planning, Medicaid for long-term care, landlord tenant law, and much more. And we'll talk to you for free. The topics that this presentation will cover are the landlord's obligations, the tenant's obligations and rights, evictions and damage deposits, as well as evictions in mobile home parks and in subsidized housing. So what are the landlord's obligations? The landlord is obligated to make repairs to keep the property in a safe condition, to maintain in good working order all electrical, plumbing, heating, air conditioning, and other appliances that are supplied by the landlord, to supply heat, running water, and a reasonable amount of hot water, and there are many more obligations. And the landlord has to meet local housing codes. For instance, in Albuquerque, the landlord is always responsible for extermination when there is an insect or rodent infestation that's caused by poor maintenance or that is in common areas of an apartment building. Additionally, in Albuquerque, the foundation, floors, walls, ceiling, roof must all be reasonably weather tight, in good repair, and capable of affording privacy. Now, and there are many more housing codes in Albuquerque, and housing codes in different areas will be different. If the landlord violates any obligations affecting health and safety, then the tenant can give notice to the landlord of those violations in the form of a 7-day notice of abatement. If the landlord must remedy those violations within 7 days. If the landlord fails to completely remedy the violation, then the tenant can withhold 1/3 of the rent prorated on a daily basis. And that gets pretty confusing. So if you're in that situation and you want to know how much you can withhold, please give us a call and we'll go over it with you. If the landlord fails to take any reasonable steps towards a remedy, then the tenant can terminate the lease. Additionally, if the unit is uninhabitable and the tenant moves out, then the tenant can withhold 100% of their rent, prorated on a daily basis going forward. Now, the tenant can usually call code enforcement to request inspections of code violations. Some areas code enforcement doesn't do this, but it's definitely worth a call. If a violation is found, then code enforcement will notify the landlord and the tenant can use those findings in court later if needed. Now, the tenant does also have obligations. First of all, make sure both parties sign a written lease. That's in your best interest. Additionally, the tenant must comply with minimum standards of housing codes that affect health or safety. The tenant must abide by all applicable bylaws, covenants, rules, and regulations. The tenant must keep the premises as clean and safe as when the tenant moved in, except for ordinary wear and tear. And the tenant must not deliberately or negligently damage or remove any part of the premises, must not disturb neighbors' peaceful enjoyment of the premises, and must not knowingly commit or consent to any other person knowingly committing a substantial violation, which I'll talk about in a minute. Now, what are the tenants' rights in general? First of all, when the landlord needs to perform inspections or to show the home to a prospective or the unit to a prospective tenant or to perform unrequested repairs, the landlord must provide 24-hour written notice with an approximate time and reason for the visit, except in cases of emergency, in which case that doesn't apply. If the landlord's proposed time doesn't work for the tenant, then the landlord must try to accommodate the tenant's request for an alternative time. Now, landlords cannot evict without a court order. If the landlord forces the tenant out, whether it's locking the doors or turning off the utilities, the landlord may be subject to a 2-month rent penalty. The process that the landlord must follow is, first, the landlord must give written notice with a certain number of days for the tenant to move out. And the number of days depends on the circumstances, and I'll get into that shortly. If the tenant doesn't move out after that number of days has come up, then the landlord must file a petition for restitution in court. The landlord still cannot evict. The landlord has to go to court. And then the tenant is served with a summons for a hearing with a judge, and the judge is the one who decides whether or not the tenant is evicted. If the tenant is locked out, the tenant should call the police. They might not help, but hopefully they will, and hopefully they will inform the landlord that a court order is needed to evict. If not, there will at least be a police report on file, and the tenant can file action for possession in magistrate court. And if that happens, just give us a call for some help. Additionally, the rent cannot be increased during the term of the lease, and late fees are not allowed unless they are written in the lease, and they can be no more than 10% of the monthly rent. Now, what are the different types of eviction and the certain number of days that I was just referring to? So if it's for non-payment, if the eviction is for non-payment, then the landlord has to give the tenant a 3-day notice of non-payment. If the landlord is terminating the lease, either upon its expiration or just a month-to-month lease, then the landlord has to give the tenant a 30-day notice of termination or non-renewal. Now, the landlord does not need a reason for this type of eviction. And the landlord must provide 30 days before the next rental period. And that gets confusing, so if you have questions about whether or not your notice is proper, whether you got the proper 30 days, please give us a call and we'll go over your specific circumstances. There's also a 3-day notice of substantial violation, which I'm going to talk about in a second, and a 7-day notice of non-compliance. So what is a substantial violation? That is intentional or reckless damage to property or felony type violations that occur within 300 feet of the premises. Now, the landlord must only prove that it's more likely than not that the violation occurred, but the notice must explain exactly what the bad conduct was and when and where it occurred. And if there's no real basis for the notice, then the judge might not order the eviction and the landlord might be subject to a rent penalty. For instance, if the landlord posts a 3-day notice of a substantial violation claiming that the tenant is dealing drugs from his home, but the landlord has no evidence of that, then the tenant might be able to stay in the home and also receive an award for damages in the amount of 2 months' rent. Now, the 7-day notice of non-compliance, that is for material non-compliance or for non-compliance with the tenant's obligations, which we discussed a little bit, that materially affect health and safety. Now, what's a material non-compliance, either with a rental agreement, apartment complex rules, or law? What is a material non-compliance? That's, for instance, if the tenant gets a dog and the rental agreement says no pets. That's material non-compliance. The tenant must find a new home for that dog within 7 days from receiving the 7-day notice, or the tenant will have to, or the landlord can go to court and start the eviction process. The tenant must remedy the breach within 7 days. Additionally, a second breach, even if it's for a different noncompliance, within 6 months may result in another 7-day notice with no opportunity to remedy. So the tenant will have to be out in 7 days or face restitution in court. And again, the notice must contain dates and specific facts. Now moving on to damage deposits and belongings. Damage deposits must be returned within 30 days along with an itemized list of damages. Now, if there are damages, then the full damage deposit, of course, doesn't need to be returned. It'll be the balance of the damage deposit minus those damages. And the 30 days are either 30 days after you move out, or you being the tenant, or if the tenant moves out before the end of the rental period, then it's 30 days from the end of the rental period that the landlord has to get that damage deposit back along with the itemized list of damages. If the tenant leaves behind personal belongings, then the landlord must provide the tenant reasonable access to retrieve them. If the tenant was evicted, then the landlord only has to provide that access for 3 days. If the tenant moved voluntarily, then the landlord has to provide that access for 14 days, but the landlord can charge reasonable storage fees. And if the time limit has expired and the fair market value of the belongings is over $100, then the tenant can either sell or keep the property and reimburse the tenant for the fair market value, or dispose of the property and not pay the tenant back. For instance, if the tenant receives a 30-day notice of non-renewal and moves out within the 30 days, but leaves a couch and a bed in the unit, the landlord must keep and provide access to that furniture for 14 days, although the landlord can charge reasonable storage fees. And if the tenant doesn't get the belongings after those 14 days and the landlord keeps the furniture, then the landlord must pay the tenant that fair market value. Now, mobile home park tenants have special protections if they own the mobile home and are renting space in a mobile home park with 12 or more units. So the tenant has to own the mobile home and the park has to have 12 or more units for these special rules to apply. If that is the case, then the 30-day notice of non-renewal is no longer an option. The landlord must give a 3-day or a 7-day notice plus a notice to quit. So the landlord must have a valid reason, such as a substantial violation, a 7-day notice for a substantial violation, or a failure to pay, 3-day notice of non-payment. It cannot simply be that the lease has expired. The notice must include the date, place, and circumstances of the acts justifying eviction, and the tenant will have 30 days from the end of the rental period when the notice was received to move the home. And if it's a multi-section mobile home, then the tenant has 60 days from the end of the rental period when the notice was received to move the home. So that's pretty confusing. If you're in that situation, just give us a call and we'll tell you exactly what applies to your situation. And finally, eviction in subsidized housing. For public and private HUD subsidized housing, the landlord cannot refuse to renew a lease without cause, but that does not apply to Section 8 housing, to Section 8 vouchers. The tenant does have the right, but not the obligation, to request a pre-termination grievance hearing and to review the tenant's file at the Public Housing Authority. The tenant should always do both of those things because it gets the tenant more time. And it's also called, this pre-termination grievance hearing is also called an informal hearing. So you might hear it being called that. Otherwise, the landlord must follow the regular rules. Give the notice and then a petition for restitution. If it's for non-payment of rent, the notice grows from 3 days to 14 days in subsidized housing. And if it's for other grounds, it's 30 days notice. Now, eviction usually does result in the loss of a Section 8 voucher. So if eviction is inevitable, it's usually better to agree to move and request a transfer voucher. And finally, what are the typical grounds for eviction? in subsidized housing. First is non-payment. If that happens, ask for a repayment plan at that grievance hearing. Another is unreported income. If a tenant is in subsidized housing, then the tenant has to report any changes in income, either to the housing authority or to the landlord, whoever the tenant pays rent to. Other typical grounds are unauthorized household members, drug-related criminal activity, violent crime, or any other crime that affects the health, safety, or welfare of other residents. That's it for this presentation. If you have any questions about the video or any other civil legal matter, we encourage you to contact our program. You can reach us statewide at 1-800-876-6657 or locally at 505-797-6005. We also have more information on landlord-tenant law on our website, as well as a bunch of other civil legal issues. We do encourage you to call. We'd be happy to talk to you. Thank you for watching this presentation. Additionally, during the COVID pandemic, tenants are being provided more protection from eviction. Please also watch our presentation about those additional protections during this time.